more like they would at the peak of the season in, mid-September or so. As far as why they're so warm, I think there's a few ingredients in there. I don't think there's a great consensus overall. Certainly climate change is playing a role. It plays a role in a lot of things. I don't think that's responsible for the relatively abrupt jump that we've seen in ocean temperatures in the past year, but it's certainly an ingredient.
And climate change, you say, can decrease the overall number of tropical cyclones, but increase the strength of those storms. Why is that?
There's a lot of complicating factors that go into what makes a hurricane. And it's not just a warm ocean. You also need low wind shear. You need the upper parts of the atmosphere to stay cooler. So if the upper parts of the atmosphere warm, along with the ocean temperatures, that's actually kind of a net zero change for a hurricane. So there's a few other things besides just how warm the ocean is, but that's certainly a key player.
So what else are you watching for as we get further into this hurricane season?
This is an ABC News special report.
Good morning. I'm Whit Johnson in New York. We're coming on the air with major breaking news from the U.S. Supreme Court on the final day of its term. The High Court has just issued one of its most consequential rulings in recent decades, a decision that not only affects the 2024 race for president following last week's contentious debate, but also the future of the presidency itself from this day forward. Moments ago, the justices ruling on Donald Trump's claim of absolute immunity from criminal prosecution, his core argument in both the 2020 election interference case in Washington, D.C. and the classified documents case in Florida. The court deciding this morning presidents do have immunity for official acts, but there is no immunity for non-official acts. The court then sending it back to the lower courts. So let's get right out to ABC's senior national correspondent, Terry Moran, at the Supreme Court. And Terry, as we noted, this goes far beyond former President Donald Trump, but presidents in the future.
Absolutely. This is a ruling, the biggest ruling on presidential power in decades. All future presidents will have to reckon with it. And it is a 43-page opinion that basically says there's more work to be done in this prosecution at the lower level. But the court did, as you suggest, have to outline the big question. Donald Trump's claim that former presidents are absolutely immune from prosecution, can never be prosecuted for any of their official acts. And in this case, the court says that a former president may have some immunity from criminal prosecution for official acts during his tenure in office. And then comes the fine print. And what the court does here is steps through each of the actions of former President Trump in his alleged conspiracy to overthrow the 2020 election, his conversations with Mike Pence, pressuring Mike Pence, his conversations with Justice Department officials, pressuring them, his conversations with state officials, and his speech on January 6th. And in each instance, the court takes a look, raises the issues, and sends it back down to the trial court to figure out, under this guidance, is Trump immune on each of those areas of evidence in this prosecution? What it means is a lot more work at the trial court and a lot more delay for this trial. We'll take a deeper look at it, but that's the basic outline. Trump does not have absolute immunity. He can be prosecuted, but it depends on how the lower court looks at this opinion in each of those very fact-specific areas.
Terry, thank you. And stand by here. Let's bring in our senior Washington reporter, Devin Dwyer, who's also been following this. And Devin, it's worth going back to some of these oral arguments in April because we to a degree, saw some of this coming with the justices already suggesting presidents need some immunity. So how does this now play out going forward?
Well, this is in no short sense, Whit, a big win for Donald Trump. It means delay. We already knew that a trial on these charges would be unlikely before the presidential election. Now it's all but impossible based on today's decision. And I want to just quote for you it's from the dissent here. This is a Supreme Court that is sharply divided on this issue along ideological lines. This was a 6-3 decision. The conservatives issuing that decision that Terry just outlined. The liberals in this case dissenting speaking very, very sharply in stark language. In fact, Justice Sonia Sotomayor said today that the court gives Donald Trump all the immunity that he asked for and more. She accuses the court of an atextual, ahistorical, and unjustifiable immunity test that, in her view, puts the president above the law. So as much as many court observers had hoped that this court would somehow try to find a decision that would unify on their bench and the country, they did not do that here, and this is a sharply divided opinion.
All right, Devin, thank you. Let's come back here in the studio with our chief Washington correspondent, John Karl, who's with me here at the desk. And we were talking about this earlier because this is not just about the January 6th case. There's a documents case and other charges. And there's been a lot of frustration from Democrats and those who would like to see the former president held accountable. More delays ahead now.
Look, this is an absolute win for Donald Trump, not just the substance of the opinion, but also the court had the option here to make the decision effective immediately or go through a traditional waiting period of 25 days. There's no expedited period. This effectively grants Donald Trump blanket immunity because it makes it seems to me now, impossible for a trial to go forward, either in the classified documents case, because this is also at stake there, and the January 6th case. And I think when you look at the dissenting opinion, Devin read part of it. This line stands out to me. Says the decision, quote, makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Now, look, this decision doesn't say that what Trump did in his effort to overturn the election is covered by this immunity, but it would take time. It's going to take time that simply isn't there, and you have an election coming up, and you have Donald Trump has made it abundantly clear that if he wins this election, this case goes away.
And the timing is so key here. And I do want to put that graphic back up on the screen. We were listing out the various charges because now the special counsel would have to take another look at all of this. That's the graphic there, the Trump criminal trials and the charges there. Let's bring in Rachel Scott, our senior congressional correspondent. Also, you've been out on the campaign trail. Rachel, you were there on January 6th. You've also been following closely what the Trump campaign is saying. And even this morning, he's been following this, and he's been posting things on social media and even deflecting and saying, it's not that big of a deal for me. Maybe it's something Joe Biden should worry about when it comes to presidential immunity.
Wait, I'm told from a senior advisor to the Trump campaign that we are expecting a statement from the former president at any moment now. Actually, we just got it. The former president says that this is a big win for our Constitution and democracy. Proud to be an American. That is the first reaction coming in from Donald Trump to this ruling today. Out on the campaign trail, he has made retribution a core part of his message. We saw it on the debate stage just days ago. He said that this would have big implications, not only for him, but also for future presidents, including President Biden, saying that in the future, President Biden could also have to be faced with something very similar to this. There is no question about it. As John Karl just noted, this is big for Donald Trump because time is something that his campaign, that the former president, were deeply worried about. They did not want to see this trial happen any closer to Election Day, Whit.
And can I just make one very quick point? So while it is an absolute total victory for Donald Trump in the legal sense, the court does not affirm what Trump has been saying on the campaign trail. Trump has been saying that presidents have absolute immunity for anything, that you cannot charge a president or a former president for anything that happened while he or she was president. But the court does say, in the opinion, there is no immunity for unofficial acts. The president is not above the law. The issue here is that it's going to take time to adjudicate what is or is not an official act in the case against him.
Yeah, and sort all of that out. Absolutely, will take time. Let's go to the White House. Our senior White House correspondent, Selena Wang, is there. And Selena, you're already getting response from the Biden administration. We know in the past, President Biden has said he can't see any reason why a president would have absolute immunity. What are they saying now?
Yeah, Whit, that's right. And for the Biden campaign, this case underscores the core theme of President Biden's re-election, the stakes of this, their message that Trump is a threat to democracy, someone who is obsessed with power. And in a statement that they just sent over, they said, look, today's ruling does not change the facts. So let's be very clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election and encouraged a mob to overthrow the results of a free and fair election. Trump is already running for president as a convicted felon. Now, the campaign, Whit, has also been warning that if Trump gets a second term, there will only be darker days ahead, that he will continue to try and shield himself from prosecution. With this campaign has been saying now for quite some time that Trump wants the power of a king or a monarch, to have absolute power without accountability. So the Supreme Court decision today does not change their messaging on those points.
All right, Selena Wang for us. Thank you so much. I want to bring in Kate Shaw, our Supreme Court contributor. And Kate, I think it's worth, again, going back to some of these oral arguments in April, because the justices laid out just how important and consequential this is. Justice Neil Gorsuch said, we're writing a rule for the ages. Justice Kavanaugh said the court's decision would have implications for the future of the presidency and the future of the country. So now that we're looking at all of this now, have we answered some of those questions about what would be an official act that a president could have immunity from and what wouldn't?
Well, Whit, I think it's definitely right that this is an opinion the court has written for the ages. It's probably the most important Supreme Court opinion about the power of the presidency and protections enjoyed by the president since Nixon versus United States, almost exactly 50 years ago. So that was a July 1974 opinion. And the court in that case rejected Richard Nixon's arguments that he didn't have to cooperate and produce Oval Office tapes. Many of his arguments echoed in lots of ways arguments made by former President Trump here. So that case was a unanimous loss for the former president. This case is not unanimous, but a very big win for former President Trump, recognizing for the first time this sort of immunity of ex-presidents from criminal prosecution, not for everything they do, as John Carl was saying. So unofficial acts are still subject to prosecution, but recognizing this kind of immunity, some absolute immunity for core presidential functions, some qualified immunity for other official acts, that seems to be what the opinion says, is an enormous addition of new powers and protections to the president in a way we just haven't seen before. So I think the dissent is quite right to say this is a seismic opinion, and in many ways it is hard to square with previous constitutional decisions.
And Kate, just to follow up on that and to see how this plays out in the lower court now, you talked about the hypotheticals. I mean, the justices were bringing up everything from what if a president stages a coup? What if a president assassinates a rival? So how do those questions get answered moving forward?
You know, I think that all of that, right, so the lower courts initially will take a look at what's in Jack Smith's allegation, right? Some of what is alleged having to do with the vice president or the Department of Justice, pretty likely or definitely official conduct. Other things, right, trying to generate fake slates of electors, that is probably on the unofficial side of the ledger. So as to the conduct at issue here, the courts will be examining closely how this new test applies. But those hypotheticals, I mean, I think it's pretty clear that some of those very, very extreme hypotheticals would fall on the official side of the line. If you're the president and you're ordering even unlawful action by subordinates, that's acting in your official capacity. Only the president can do that. And so I think it's pretty clear that this case has blessed the idea that some of that conduct, really extreme conduct, would be subject to immunity forever if engaged in by a president. And I think that's, you know, that's why the stakes of this case are so high.
All right, thank you. Let's bring in ABC News investigative reporter Catherine Faulders. Catherine, I know you've been talking to Trump's legal team and all of this. They were focused on this case, not just, again, about the January 6th case, but also the documents case. What's their reaction today?
Right. I was just on the phone with a source close to Trump's legal team, and the quote that they gave me, and they're still reading through this just like us, but they say this is as good as it could possibly be without absolute immunity. Obviously, that's for the reasons that we've been discussing. This is a very detailed opinion. They're focused on some of the language in this opinion that single out Trump's words, for example, obviously Mike Pence, as we've also been talking about. But this is something that maybe they predicted, but didn't predict that it would go this much in their favor. Now, of course, they didn't find absolute immunity, but this essentially stalls this. There likely won't be a trial before the election. There will be a lot of litigation at the D.C. District Court down the street. But they also are focused on the fact that this could affect Florida. Remember, the judge there has essentially stalled the proceedings in Florida. That's the classified documents case. The Trump lawyers filed a motion there based on presidential immunity. They want the case thrown out. They say that Trump was immune in the classified boxes case because when he landed in Florida, he was still president, and therefore that's an official act. Now, the judge there will likely schedule hearings as well in this. The judge, Judge Cannon, who oversees that, appointed by Trump, has indicated that she wants to wait to rule on that immunity motion until the Supreme Court weighed in. Well, they have. We could likely see hearings down in Florida on this as well.
All right, Catherine, thank you. Let's go back to Terry Moran at the Supreme Court. You're getting more information on sort of the practical implications here.
Precisely how this decision works. There's a big principle that we've already articulated that Chief Justice Roberts expresses this way. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law, but he goes on to say, Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch, and the president therefore may not be prosecuted for exercising core constitutional powers and is entitled to presumptive immunity. That means the trial court, each time the special counsel says, well, we want to prosecute him for this act or that act, we'll have to presume the starting point of the analysis is that the president is immune. And the court actually did some work in that regard on one instance. In December of 2020, President Trump, late at night, called in the Deputy Attorney General Jeffrey Rosen and other officials and pressured him to get on board with the Trump campaign and challenge results in Pennsylvania, Georgia, and Michigan. And Rosen refused, and Trump threatened to fire him. The court says that is core constitutional protected presidential activity. And it says, what Chief Justice Roberts says is that because, as president, Donald Trump can fire anybody he wants in the executive branch, that cannot be criminalized, even if it was done, as the allegation is in the prosecution's case, to further a conspiracy to overthrow the results. Because it's firing an executive branch official or demanding action by an executive branch official, it cannot be criminalized. So he totally wins on that count at the Supreme Court, and the lower court is going to have to deal with a very high bar that the court establishes here to prosecute a president.
And Terry, laying out some of those specific examples, that will be key as we move ahead here. Terry, thank you. I do want to bring in our Chief Justice correspondent, Pierre Thomas, because, Pierre, this decision is going to impact the credibility of the DOJ and the special counsel. So how do they approach this going forward now? Do they re-examine some of these charges?
Well, clearly today, this means that the likelihood of a trial before the November election is almost impossible. And what, based on conversation with DOJ officials, I expect to happen is the following. The judge and DOJ have a lot of work ahead of them. The bottom line for DOJ, they will have to look at each aspect, each part of the case that they brought. And one of the things I talked about earlier with sources is that they may make the case that when Donald Trump took these actions, he was not acting as president, he was acting as candidate. And we will have to see if that's effective with the judge in terms of parsing through each individual aspect of the case. But clearly, DOJ will have to make some of the most significant decisions they've made since bringing the case. And at the end of the day, DOJ has to resolve this issue. They decided that Donald Trump, as president, was acting as a criminal. They charged him. Now they have to break this down again, present it to the judge, and see if they can go forward with the case.
All right, Pierre, thank you. Let's go back to Devin Dwyer in Washington. And Devin, again, it is important to point this out to our viewers. This is very confusing, right? We had a lower court say one thing, the Supreme Court says something else, Trump's team and the DOJ all saying something different. So bear with us as we dissect this in real time. But you're getting more detail about the specific charges here, right?
Well, the top lines that we've been talking about, that this being a very good day for Donald Trump in terms of the timing of any potential prosecution is very significant and historic, as we've been laying out. But the Supreme Court makes clear by writings by Chief Justice John Roberts that in no way is this a free pass for Donald Trump. Yes, the court, as Terry was just saying, gave explicit absolute immunity in writing for the former president's conversations with the Justice Department. But John Roberts writes at length in this opinion, laying out what is still fair game. Yes, this will take time for the lower court to parse what is immune, what is not immune, what's official, what's unofficial. But Roberts explicitly said that the former president's interactions with Mike Pence, pressuring him on the certification of results, the former president's contact with state officials, private parties, Rudy Giuliani and others, comments to the general public on Twitter on January 6th, all of that could potentially be prosecutable, John Roberts says. And in fact, he pushes back on the dissent who said this decision puts former President Trump above the law, and John Roberts writes that they have concluded a wholly disproportionate judgment on what the court says today. And John Roberts says there's still a lot of work to be done, but a trial can ultimately go forward, just not anytime soon.
All right, Devin, thank you. Let's come back to the studio and bring in John Carl again, because I want to dig into the documents case a little bit more. The documents were taken while he was president. he held them at Mar-a-Lago after he was president, famously saying they're mine.
Yep.
So how does that factor into all of this?
So as you heard Catherine Falders point out, the Trump legal team has argued because he took the documents while he was president. In fact, when he landed at Palm Beach, he was still president, that this is an official act, having the documents. But that's not what he's charged with. He's charged with refusing to return the documents. He's charged with obstruction of justice. He's charged with failure to comply with a subpoena.
After he was president.
Long after he was president. This all happened, as you remember, the search warrant in Mar-a-Lago was in August of 2022. And all of these, and you remember the details of the case against him, the way they moved the boxes around to effectively try to hide them, the way he allegedly tried to destroy the surveillance video that showed the documents being moved and being hidden. So I think that certainly it's something they're arguing, and the judge in that case, Elaine Canyon, has said that she'll have a hearing on this, was waiting for this case to play out to the Supreme Court. But to be clear, the allegations in the classified documents case are not related to Donald Trump's official actions while he was president of the United States. They're things that happened long after he was president.
And Rachel Scott, again, it's worth emphasizing once more, a delay is a win for Trump.
Yes. Political versus dismantling the allegations are two completely different things here. So yes, this is a political win for Donald Trump in the sense that his campaign, the former president, does not want to see this go to trial before the election. But this does not mean that there's no credibility to any of the allegations against the former president. And when we're talking about the classified documents, I was just looking at my notes here, was on the plane with the former president back in June, traveling with him. I asked him directly if he had any regrets in the way in which he handled those classified documents. He told me flat out no. He has no regrets whatsoever, claiming that it was all simply bravado.
All right, Rachel Scott, John Carl, thank you. I do want to go back to Terry Moran at the Supreme Court. Terry, just give us the big picture here. We've had a little bit more time to dissect this decision. What's the big takeaway here?
Well, with this was the first case like it in the court's history, a case of first impression, as they say. And it was going to define presidential power, not just for Donald Trump, but for future presidents, no matter how it came out. And it came out in a way that will empower presidents in the future to act, as the majority in this case says, with boldness and fearless impartiality. And it will also embolden presidents to act right up to and perhaps beyond the bounds of the criminal law. The last words of Justice Sonia Sotomayor, disagreeing with what the court did here, is that never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide by will not provide a backstop. That's the concern.
All right, Terry Moran, thank you. Let's go back to John Carl here again as we're reading more of this decision. We have the political implications here as well. And you were referencing a specific incident that's getting a lot of attention.
Yeah, you remember when the argument came before the court, this example was given about SEAL Team 6. If a president ordered SEAL Team 6 to assassinate a political opponent, would that be immune? And Trump's lawyers said yes, it would be, unless the president was first impeached and then tried. So it's interesting to read the dissent here. Again, Sotomayor writing the dissent, saying the president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he is now insulated from criminal prosecution. And then she goes through examples. Orders the Navy's SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, immune, immune. That's how Sotomayor sees the implications of this decision.
And again, that decision along ideological lines there with the 3 liberal justices, teaming together and the 6 conservative justices with that decision. Rachel Scott, also want to talk about all of this coming, of course, after that consequential debate that happened last week. Politically, according to polls and people who are watching, it appeared that obviously President Biden had a poor performance, but many thought that Donald Trump won the debate despite the cascade of false statements that were made. But this is a good couple of weeks for former President Trump as he heads towards the convention.
Yeah, you have the debate, you have this ruling coming down. We know the former president is going to campaign on this as a complete and total victory. We obviously differentiated between the two realities of that, both politically and also just the weight of these allegations against the former president. But also, Whit, just to make absolutely clear here, the former president's about to be sentenced in just a number of days. And so there's still a lot to be said about the legal challenges that Donald Trump faces.
And the former president did get a big boost in fundraising after that conviction as well. So we'll see how the rest of this plays out. Rachel Scott, John Carl, our entire team, thank you so much. Again, we're going to return you to regular programming. For some of you, that's Good Morning America in some parts of the country. Our coverage does continue here on ABC News Live and abcnews.com. You can also get breaking news alerts on the ABC News app. The entire team, again, will be right back here tonight for World News Tonight. For now, I'm Whit Johnson in New York. Have a great day.
This has been a special report from ABC News.
Hi, I'm Diana Macedo. You're watching ABC News Live special coverage amid that breaking news. The Supreme Court just ruled on former President Trump's immunity case, saying presidents do have immunity for official acts while in office, but not for unofficial acts. In a historic 6-3 ruling, the justices then ordered lower courts to figure out precisely how to apply that decision to Trump's January 6th case. For more, I want to bring in ABC News political contributor Sarah Isgur. Sarah, the courts are saying here that the president enjoys no immunity for his unofficial acts. And Chief Justice Robert makes clear in this decision that not everything that the president does is official. So what are you watching for now for how the lower courts go about dissecting what is and is not official in this January 6th indictment?
Well, in fact, you can really think of it as three different buckets. So on the one hand, unofficial acts, if the president punched someone in the Oval Office, that would be an unofficial act. He could still be charged with that. And then on the other side of that, you have core official acts. Those are things that the Constitution places solely in the responsibility of the president. Think here about the pardon power. So they're saying the president is absolutely immune from being charged for exercising his pardon power, and this was actually in the January 6th indictment from the special counsel, or trying to remove his attorney general. Removal power is a core executive power in the Constitution. So those are absolutely immune. The issue for the lower courts will be determining what are those unofficial acts, what are those core official acts, and then what about those acts that are somewhere in between? They are official acts of the president, but they're not solely the exclusive powers of the president. The president shares those powers with Congress. So here, think about everything else in that indictment related to investigating election fraud, for instance. The president has claimed that's his executive power to do so. Congress, of course, also has power to do that. That's where the rubber's going to hit the road on this special counsel indictment, I think.
I want to bring in our ABC News senior national correspondent, Terry Moran, for more, because, Terry, it's kind of a mixed bag. On the one hand, this decision does leave open the possibility that former President Trump could still be prosecuted for what they deem unofficial acts, or what the courts deem unofficial acts, while he was in office. But it makes it almost impossible now that this January 6th case will actually happen before the November election.
There's no question about that. It was a close-run thing anyway, if a trial at this date could be held before the November election. But this opinion requires a great deal of work by the parties, the prosecutor and the defense, and by the trial court and then the appeals court on interpreting this decision for the facts of the Trump case. And beyond that, it sets a very high bar for prosecuting former presidents. The language in the opinion is that former presidents have presumptive immunity. That whatever they're doing, that in the broadest possible interpretation can be considered part of their official duties, that they are immune, and that they are presumptively immune even for unofficial acts, like a speech on January 6th, which the prosecutors allege was an incitement to violence. That speech may be immune from prosecution under this opinion because presidents speak. They have the bully pulpit. That's core part of what they do. And so that is one of the many, many facts in this case that will have to be sifted by the lower court to figure out if Trump's conduct can be shown to be so unofficial, so personal, so much for his own personal interest, not the interest of the president, that he could be prosecuted for it. They've set a high bar. It's pretty much everything that the Trump camp could want.
And I want to talk about that sifting process with our ABC News Supreme Court contributor, Kate Shaw, because, Kate, there was an interesting moment during oral arguments where Trump's attorney actually argued that depending on the hypothetical, even assassinating a political rival could be considered an official act. So where is the line now between official and unofficial acts? Is the Supreme Court offering any guidance on that front, or is this just going to be up to the lower courts now?
There's a great deal of work for the lower courts to do. I mean, in terms of, so there are the core presidential powers that the court has said are absolutely immune. And again, that includes things like granting a pardon or appointing and removing officials. But everything else a president does, there's a real range. And I think it's, what's maybe counterintuitive is that there are things that a president could do that these hypotheticals teed up that are egregiously wrong, would violate criminal law if engaged in by anyone else, and seem like they must cross some line. But if the president is doing them as president, then they are official acts. So if the president is ordering, again, the assassination of a political rival, that's something the president is doing as president, directing subordinates to carry out some task, not something a private citizen could do. And I think that makes that kind of conduct official conduct. And that's what the dissents very clearly and explicitly say, that that is on the immune side of the line. And so I do think this opinion hands enormous new immunity to presidents, including to engage in the most egregious and destructive and anti-democratic activity. As to this particular case and these allegations in the indictment, I think the lower court's going to have to go carefully through some of the allegations, including around things like, generating fake slates of electors and trying to get state officials to change votes. And there, I think there's a very good argument that they fall on the unofficial side of the line, because those aren't things presidents have the power to do. And if they're unofficial, they could be subject to an actual, trial at some point. But of course, the time it would take to get there, I think is much more than remains between now and November. So let's bring in our Chief Justice correspondent, Pierre Thomas, because Pierre, what does this mean for the Justice Department now? Does Jack Smith go back to the drawing board and try to make the case for each count of this indictment as to what is official or unofficial?
Well, in practical terms, I think the possibility of a trial before the November election is unlikely, if not impossible. What the DOJ, we expect them to do, and the special counsel as of right now is not commenting. They tend to want to speak in court. But I think based on what we've been hearing from sources, they're going to take some time to think about this ruling, to study it closely. But then the trial court the judge and also the special counsel will have to look at each one of the charges brought and look at how they can design the case before the judge to meet legal muster. And one of the things that they had talked about in the past in some of the early filings before the court is that Donald Trump, in seeking to overturn the results of the election, was acting as a candidate in his personal capacity, not as the president of the United States. So to the degree they can make that argument and to the degree the court buys that argument, that is sure to be litigated going forward.
And I want to bring in our Chief Washington reporter, Don Carl, our senior congressional correspondent, Rachel Scott. If the January 6th case, John, doesn't happen before the election, and former President Trump doesn't win the election, he presumably would stand trial at some point soon thereafter. What happens if he does win?
I don't think there's any question what happens if he doesn't win. Donald Trump has made it clear that he is going to stop this case. He will, the first thing he will do as president will be to fire Jack Smith. He'll have his own attorney general nominated. This thing goes away. It simply goes away. But I think that there are two very important points here. One, this case does not prevent this, does not prevent the case against Trump to go forward in a vacuum. I mean, if there were plenty of time, if there weren't this election, they could sift through, they could figure out which were official acts, which were non-official acts, and the case could go forward. There's absolutely, as I could say, I don't think there's any chance that happens before November. So it effectively grants him blanket immunity because this won't go forward if he wins. But remember, as you heard in the arguments, this is a case for the ages. This doesn't just affect Donald Trump. And I want to read what I think is a stark section of the dissent here from Sotomayor about the broader implications, not the case of Donald Trump, but the broader implications for presidents from here on in. And she writes, the implications of this is that when he, a president, uses his official powers in any way under the majority's reasoning, he is now insulated from criminal prosecutions. Orders the Navy's SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, immune, immune. And then she goes on, let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may not one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. And I think that, I mean, we'll see how this play out. That's obviously not how John Roberts would describe the majority's opinion, but it makes it clear the presumption for official acts is immunity.
And I know we're getting a lot of reaction. Rachel, I want to get that from you in a second, but first I want to take that point to Kate. Kate, what do you make of this back and forth and how differently the justices seem to be looking at this issue and the repercussions from it?
You know, I think the majority is at pains to say this is not handing Donald Trump everything he has asked for. We are not granting this kind of sweeping absolute immunity for any and all action and any and all time. I'm having a difficult time squaring that representation, honestly, with what the rest of the opinion says, which is that there is an enormous amount of immunity that presidents enjoy. And there's the Sotomayor dissent, which John was just talking about. There's also a short, separate Jackson dissent. And Jackson says, well, the court is suggesting that the court itself is going to be in the position of restricting presidents from becoming kings through this kind of case-by-case application of this new test about official immunity. And under some circumstances, this immunity might give way to prosecution. But I think she says that is far less effective than a clear rule that she thinks has always been the governing rule, which is that once they leave office, presidents become just people and they're subject to prosecution and subject to the law like anyone else. So, I mean, to my mind, for what it is worth, I think that the majority seeks to underplay the breadth of the announcement that it makes today. But I think the dissent is right that this is a seismic change in presidential power and presidential accountability. And anything to the contrary in the majority opinion is just an effort to kind of blunt the sort of force of the kind of reception of the opinion. But I think it's an enormous win for both Donald Trump and future presidents who seek to shield themselves from accountability.
You nodding. You want to add to that? Terry?
Justice John Roberts answers Sotomayor. He calls the dissent fear-mongering on the basis of extreme hypotheticals about some future where the president feels empowered to violate the criminal law, as if we can't imagine such a future at this late date in our history. And he goes on to say we're gusting up here, there's a far more likely prospect of an executive branch that cannibalizes itself, with each successive president free to prosecute his predecessors. It is hard to overstate how in some places the wave of prosecutions of Donald Trump that followed his departure from office, which may, obviously in the minds of prosecutors and grand jurors, justified by facts and evidence, but how it shocked many constitutional lawyers like John Roberts that this threatened the strength of the presidency and the health of the democracy if every succeeding president, as Donald Trump himself is saying, could find retribution and revenge by prosecuting his presidency. That's the motive here for setting the bar so high, for presuming that presidents do have immunity, and for making it very tough to pursue not just Donald Trump, but future presidents as well. That's the justification in the court's opinion.
So, Rachel, let's talk reaction now, because you are hearing from both the Trump camp and the Biden team. What are they saying about this decision?
Yeah, so the former president did weigh in. We know that he was closely monitoring this. He has been posting on his social media account, Truth Social, about it before this ruling even came down. In a statement, he calls this a big win for our Constitution and democracy, saying that he's proud to be an American. Look, the former president is going to be campaigning on this very point. He's going to be going out and claiming that this is a big victory. As John Ron Karl notes, there is a difference between the political reality of this, the likelihood that a trial would be happening. The former president and his campaign did not want to see that happen anywhere near the election. He's about to be sentenced in that hush money case in just a matter of days. Then he goes on to accept the Republican nomination for president, campaigning as a convicted felon. On the other side of this, the senior advisor to the Biden campaign says that today's ruling doesn't change the facts. So they say, let's be very clear about what happened on January 6th. They go on to say that Donald Trump snapped after he lost the 2020 election and encouraged a mob to overthrow the results of a free and fair election. We know that President Biden is making democracy a core part of his campaign message. So expect to still see these two completely different split screens, each side sort of interpreting this in a different way. But there is no question about this. This is a win for the Trump campaign.
And our senior White House correspondent, Selena Wang, is at the White House right now. Selena, what are you hearing from the White House on this?
Yeah, Diane, well, we're still waiting for the official statement from the White House, but the president has said before that he sees no reason for any president to be totally immune from criminal prosecution. Diane, we have heard from the campaign. They're out with a statement, and the campaign really sees this as raising the stakes of this election. They've already been hammering home that democracy is really on the ballot here, and I'm told that the campaign also sees this as the Supreme Court justices giving Trump a free pass. And Diane, I just want to read you a bit of the statement from a senior campaign advisor saying that today's ruling does not change the facts. So let's be very clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election and encouraged a mob to overthrow the results of a free and fair election. Trump is already running for president as a convicted felon. And Diane, the campaign has been saying that if Trump is elected for a second term, there will be darker days ahead, that he will rule without accountability. They've been saying that Trump is someone who wants to rule like a king or a monarch. They've been hammering home that he wants absolute power without any accountability, Diane.
And Terry, one of the arguments that went back and forth here is whether presidents need immunity in order to do their job well. Trump's team argued that they do, that you don't want a president debating acts of war or other big acts in office while worrying about, oh, could I be prosecuted for this later? Is the dissent taking that on in any way when they are saying that this decision puts the president above the law?
Well, the dissents do acknowledge that presidents will need, some immunity for core actions, but they feel that the majority went far too far in protecting presidents. And yet, to come back to the majority, they do, Chief Justice John Roberts does talk about the need for energy in the executive, for quick decision-making in crisis times without looking over his shoulder, what will happen when I leave office? And in this case, in the briefing and in the argument, was raised several times the example of President Barack Obama, who ordered the killing of an American citizen, Anwar al-Awlaki, in Yemen in the war on terror, justified it with advice from his lawyers in the administration about the war powers of the president under the authorization to use military force. But if Barack Obama had to think twice, if he had to think, well, what if I leave office and they charge me with murder? That's the kind of concern that bothers Chief Justice Roberts a lot more than the dissent. Justice Sotomayor recognizes the core immunities that president must have and says if they take actions, however, that cross the criminal line, they should face the music.
And I want to bring in our senior reporter, Catherine Falders, for some interesting reporting on how this impacts the classified documents case. Because, Catherine, the big focus of this case was January 6th, because obviously most of the actions or all of the actions in play happened when Trump was still at the White House. But you're saying this could also impact the classified documents case. Explain that.
It could, and it remains to be seen ultimately what the Trump legal team does there, and then, of course, what the judge overseeing the classified documents case does. Remember, Judge Cannon is overseeing it down in Florida. She was appointed by Trump. Many legal experts have criticized her for stalling the case and saying that she rules with Trump most often, which she has. The way it could impact it is the Trump lawyers in all of these different jurisdictions, whether it be in New York, that criminal trial that's ended, or down in Florida, of course, here in D.C., they have filed motions to dismiss those various different cases on the basis of presidential immunity. Now, they believe that that could have some effect in Florida. Why is that? They would argue that when Trump landed down in Florida after his presidency was over, that when he landed down in Palm Beach, he was still president. He took his boxes down there when he was still president. Therefore, because he was still president, he is immune from this. These are official acts. Now, I don't know how well that argument will work. It's Judge Cannon, and she has seemed pretty amenable to these arguments. She has indicated that she doesn't want to rule on presidential immunity, let alone hold hearings on it, until the Supreme Court rules. Now, I will say, from talking to people close to Trump's legal team, they actually are really much more focused on Florida. They know that the charges Trump faces in Florida are arguably the most serious. They think that they have a pretty good chance with Judge Cannon in getting this case entirely thrown out in Florida based on this argument. Of course, that remains to be seen, but what I would expect, at least in the coming days and weeks, is that the judge down there will likely schedule hearings on presidential immunity as well. That's something to look out for, along with in D.C. Even though this case has been stayed for a while, the litigation associated with it will ramp up again. There will be hearings in Washington, D.C. Obviously, we don't expect this, at least now, to go to trial before the election, but that doesn't mean that the court activity will resume.
And Pierre, this comes after the court rejected efforts to bar Trump from the ballot in certain states. What do you make of the role this court is playing in the November election?
Well, DOJ obviously is going to have to deal with this. I would come in at it from that perspective. I think the fact that we've not had any kind of official statement from the special counsel just yet tells you that DOJ is still reading, consuming this ruling by the Supreme Court. And clearly, they're going to have to make some adjustments in how they're presenting the case. And the key is going to be, what does Judge Chutkan say in terms of looking at what was put forth by the majority in the Supreme Court in terms of this case, and in terms of what areas can the prosecutors go forward in? What areas can't they? It's all going to be litigated. And the special counsel is going to have to sit down with his team, and the attorney general is going to have to review what they come up with and make some fundamental decisions about how to proceed with this case.
And John, that's the justice side of things. What about the politics side of things?
Look, I think that the political implications of this are huge for this race, and frankly, even for the pressure that Joe Biden is facing from Democrats to bow out. I mean, you have to think about what this decision means for a second Trump presidency. Donald Trump is somebody who has said that he will be a dictator on day one. He has made it clear that in his belief, presidents are absolutely immune for anything that happens while they're president. Now, it's one thing for him to go out there and say that. Now he has the cover of a Supreme Court decision that doesn't go that far, but goes quite far in saying that anything that can be called a core official act, the president has the presumption of absolute immunity. So here it is. Democrats have been portraying Donald Trump, a return of Donald Trump to the White House, as an existential threat to American democracy. Now there's another big element of that argument, which is the cover that he has been given by the Supreme Court of the United States, which raises the stakes yet again, if they could possibly be raised further in this election. And the discussion Democrats are having right now is whether or not Joe Biden is capable of beating Donald Trump, is capable of winning this election. I think those arguments, those discussions have just gotten even more intense than they have been.
And Kay, what are the implications here for the court itself? There's been a lot of controversy over members of the court, certain questions if some should have recused themselves from this case. And now you have the second major decision that is going to directly impact this election coming down essentially on party lines, with the conservative justices all ruling together and the liberal justices all dissenting.
I'll say a couple things. One, I think as John was just saying, many of the things that former President Trump has pledged to do if given a second term are things that under ordinary circumstances would be at the very least legally suspect, right? He wouldn't be able to carry at least all of those actions out without a willing Supreme Court. And I think we just got a very strong signal that the Supreme Court is not going to be much of a bulwark against judicial overreach and excess in a potential second Trump term, right? We saw, at least on occasion in the first Trump term, that adding a citizenship question to the 2020 census, trying to end the DACA program. Actually, the Supreme Court blocked him from doing some of those things. And I'm not sure there's any reason to expect, especially after the last couple of weeks and today, that the court would serve a similar function in a potential second Trump term. And the other thing I'll say about, kind of recusals and the justices themselves, there were very serious questions about the propriety of both Clarence Thomas and Sam Alito participating in the decision of this case. It's a case that if both of them had recused, it would have come out the other way. And so those are, outcome determinative decisions to participate, even where, there was significant concern about their ability to be impartial in this case. And also, of course, there's the general conversation about Supreme Court ethics. But I think that what this court has done here is hand this enormous new immunity from legal process to the president. So the case is mostly about the president, but it's also kind of about the Supreme Court and its ability to sort of stand in judgment of all other actors and institutions and grant blanket immunity. And in some ways, like that immunity could apply to the justices as well. So I do think it's an opinion that is about the president, but has in many ways a lot to say about the court as an institution as well.
And I want to bring in 538's Galen Druk with some data on this question because, Dalen, I understand you have some numbers for us. What do they tell you about how the American public feels about this issue and the Supreme Court in general right now?
Yeah, that's an important question, Diane. When it comes to this specific issue, Marquette Law polling asked Americans nationally just last month, do you think that former presidents should have immunity for official acts, not unofficial acts where we know from the Supreme Court today they don't have immunity, but for official acts? Overwhelmingly, Americans said former presidents should not be immune. 71% said they should not be immune, and that includes significantly more Republicans than not who say former presidents should not have immunity. So to break that down just a little bit, half of Republicans say former presidents should not have immunity for official acts versus only 30% who say they should. 75% of independents say they shouldn't have immunity, and 95% of Democrats say they shouldn't have immunity. So I think you can look at this ruling as being quite unpopular with the American public. And this, as you've all mentioned, comes at a crucial time for the Supreme Court. We at 538 have been tracking approval of the Supreme Court over the past several years. And we've already seen historically high levels of disapproval of the court. Today, it's underwater by about 20 percentage points. I think there's little doubt at this point that Americans will continue to see the court as more partisan and perhaps disapprove of it at even higher rates after today.
So, Terry, what happens now?
Well, now this case goes back down to the trial court in order to look at the indictment that special counsel Jack Smith has brought, fact by fact, charge by charge, and judge under the guidance that the court has given, where the president is presumed to be immune from prosecution for actions taken in a way that could be interpreted at all as to be within the outer boundaries of his official duties, and then take a look at whether these charges can go ahead. The court also finds, apparently, according to the concurrence by Justice Amy Coney Barrett, that the prosecutors can't use official acts to help prove what they say are unlawful acts. In other words, if the president had a meeting with Justice Department officials demanding that they do things to further his efforts to overturn the election, they can't use that evidence. So it really guts the prosecution in addition to limiting its scope.
And John, you said you had a question?
I actually had a question for Terry, because you talked about the outer boundaries of official acts, which is the language that the Trump lawyers used. But the decision talks about core presidential powers, core official acts. And I'm still struggling how to square that. I see how the liberals and the dissent define it. It seems that Roberts is defining it in a different way, but what is core presidential power?
Right. That's a great question. So that is basically defined as those constitutional powers of the president defined in Article 2, the presidential article, in which that could be veto power, pardon power, the appointment and removal process, making treaties, all those things that are core presidential activities. Now, that phrase, the outer perimeter of the president's duties, that comes from the Nixon case. Nixon was sued, civil suit, for firing somebody during Watergate, and the court held that he was absolutely immune for any actions taken within the outer perimeter of his duties. And the court here echoes that official duties are official duties giving the president the widest leeway to act.
All right, we have to take a quick break. We're going to have a lot more to discuss on this decision. Terry, Kate, John, Rachel, Pierre, Selena, Catherine, Galen, and Sarah, thank you all. And again, we will have a lot more on this decision coming up. We'll be right back.
To be the most watched newscast in America,